Welcome to Work Comp Talk. My name is Carmen Ramirez, your host for the podcast, and joining me as usual, my co-host Bilal and Carmen, managing attorney at Pacific Workers, the lawyers for injured workers. We're excited to get to actually take down another FAQ video. We try to tackle some of these once a month. There's a ton of questions constantly coming in on our YouTube channels, on our TikTok pages. If you have yet to subscribe to those channels, make sure you do so. Follow us everywhere on YouTube and TikTok. Subscribe to our podcast on your favorite app. That way you get first dibs every time we upload new content, which is constantly. So if you have questions ever, please drop comments into our YouTube videos and we do answer them as best as we can. And we're excited to dump into another frequently asked question video. Note, Mr. Bilal Kassim being the attorney, this does not create a relationship between your attorney. This is not any type of legal advice. It's just answering some questions. If you do want to get a one-on-one with an attorney, we'd highly suggest for you to schedule a case evaluation with any workers' comp law firm. That way you can establish, some of those official answers to those questions you might have.
That's why most of the stuff I say is generally or it depends.
It depends, generally, for the most part. Yeah, so it is stated on our YouTube channel. So, but it doesn't hurt. Case evaluations are free. You can get them done from home now. Everyone does them via Zoom or on a phone call and stuff like that. You don't necessarily have to visit an office. You can dump them on YouTube as well. They're not official, but you'll still get somewhat of an idea of what the question or answer might be. So without further ado, follow us on YouTube. We are under, obviously, Pacific Workers. And, of course, this channel, Work Comp Talk, the podcast channel as well. So we have two channels for you. And then TikTok as well. So first question, Bilal. I hope you're ready for this one. It has to do with QMEs. We recently did dump a video regarding the QMEs. And there's Joanna Casares, who has been following us for a while. And she says, what's the purpose of the QME if the defense team still doesn't agree with the report? What can happen as far as your PTD or TPD? And she's talking on behalf of her husband who was injured back in 2022. He still has received no payments, but her idea is like, why are we even getting a QME if they are not even agreeing with the report?
So you go to a QME when there's a disagreement about the case in general, right? Like the defense denies liability for the case completely, or maybe you have a crappy primary treating physician and you don't like their opinion, so you want the QME. There could be a variety of reasons why you go to the QME in the first place. Once you're there, either party has the ability to disagree with the QME and ask the QME for another report or actually take the QME's deposition. And so you may get a QME that's favorable, but the defense may not like that. And there could be a variety of reasons. The defense may feel as though the QME didn't review the entirety of the medical record, or the QME overlooked something that was in the medical records that would have been material to their decision. Like maybe the person had a pre-existing condition to their back and there was an MRI that demonstrated that, but that wasn't something the QME talked about at all. The defense may say, hey, we disagree with this because we want to ask the QME about that prior MRI and why they didn't address that in their opinion. So there could be a variety of reasons why, and it doesn't mean automatically if the QME goes in your favor that benefits start going in. If the defense doesn't start benefits or they disagree, sometimes you have to force them to do that. You have to take them to court. You have to try the issue if there's an issue that needs trying. So sometimes the QME will give their opinion and the defense will say, okay, it is what it is. We'll pick up benefits or we'll accept the case, whatever it is. But it depends on everything that's going on in the case.
Yeah. And this is the part where it's important. And we've actually talked about this in previous videos, knowing what QME you're going to go to. There's QMEs that are insurance friendly, meaning they side more with the insurance company, though there are QMEs also that side more with the injured worker. And then there's the neutral ones, the ones that don't play sides and they do what they have to do. So it's really important to know your QMEs. Okay, so we have another one, and this is in regards to a video that we had in YouTube, and it was the video about why do workers' comp take so long? The number one question. So this person, Tony Hale, thank you for sending us your comment, says, what happens if 3 months after your surgery, your doctor quits the network and then you're assigned to a new doctor? Like, what are your options then?
So it depends on the case. There's some case law and rules out there for continuity of care. So if there's a doctor that's no longer in the network, they can actually request to continue treating you, even outside of the network, provided that you have a medical condition that requires ongoing care that's, something serious like post-surgical, conditions. People are not in a great spot. Passing them off to someone else, probably not the best idea. And so the treating physician could make the argument to the insurance company to let them continue treating you.
Right.
Assuming that's not the case, if you've done your post-surgical PT and recovery and it's just a matter of treatment, and there's nothing there that really requires your ongoing specialized care with this one particular doctor, then you probably have to find a new doctor within the network. So you could get passed off to another physician.
Is that a positive thing to happen? Like if you get passed off to another doctor, you start all over? How does that affect you?
No, especially after surgery too. And it's like doctors don't want to pick up someone else's mess in a lot of ways. And so there's a lot of cases. We see this a lot with catastrophic cases where there's so much complexity to the case that doctors are apprehensive about jumping in and taking over care because the case it's a mess. Yeah. There's a lot going on. And so to jump in as a physician and try and give the best care you can to someone when they've already had 2 or 3, 4 years of treatment, they've got, 10 different conditions going on, it's a lot.
Yeah. It's kind of like coming in with a blindfold and trying to uncover a lot of can of worms. Maybe not the best idea.
And we have that problem a lot with clients. There'll be cases where the doctor, maybe it's not them being out of network, but they've retired.
Yep.
Or they just don't want to work on the case. Whatever the case may be, they can't be the PTP anymore, the surgeon, secondary treating physician, and we have to try and find a new physician. And sometimes that's very difficult because, again, when you're trying to get a doctor to take on a case that's already midway through, it's difficult.
I can assume. All right, so we had another video recently that we uploaded about a month ago. And this was the video about keeping your medical open or settling your case, which is a very interesting question a lot of people make. Like, should I settle or should I take the medical as long as I can? And we had a person send us a comment, and they were asking if they opt out for to close out future medical with a workers' comp, does that settlement count towards... I guess they have an injury lawsuit on top of it. So it says, does this settlement count towards subrogation against my third-party personal injury suit? So this is a very complex, I guess, question. I don't know if you want to go ahead and answer it or you would just tell that person, hey.
No, I think I got it. So sometimes when you're hurt at work, it's due to the negligence of a third party, which means that you can actually file a work comp case and you can actually sue the negligent party in civil court. And so it's the same cause of action, but that means you ultimately can't double dip. And so in workers' comp, to the extent you receive a settlement from a personal injury case, the workers' comp can assert a credit against whatever benefits in treatment you're entitled to in the workers' comp case because they say, hey, look, you already got it from the negligent party. The same principle applies from workers' comp to the personal injury case, where if you settle your workers' comp case first, the personal injury case is going to say, hey, you already got, X number of dollars. And so they're going to want to have a credit for that. And ultimately, the personal injury case is probably going to, the personal injury carrier may pay back the workers' comp carrier for the money that they've spent. But your work comp carrier, in that case, would file a lien on your personal injury case, or they'll file their own subrogation case against the third-party defendant that's actually negligent because the work comp carrier is going to say, why are we paying for this when you're the one that messed up and hurt this person?
Right. So this isn't the case like if someone, say, drives for a delivery company and they get hit by another car and that other car was the one that was liable to causing the injuries for the injured worker at that time.
Exactly. Okay. And you can't double dip. There are some ways to argue down the lien. Sometimes I've seen liens actually get dismissed. Same thing for credits on workers' comp. If the employer is negligent and caused the injury, then the amount of credit they get is actually proportionately reduced by their percentage of fault. So even if you were injured because of a third party in a car accident, but your employer did something stupid to make your injuries worse or cause the accident,
like not taking care of the car, not doing the maintenance on the car, and then the car has no brakes.
Yeah, exactly. That would be a case where the employer would say, hey, we want a credit for everything you get from the personal injury settlement. But as an attorney, I would say, wait a sec, pump the brakes. For both cases, you don't get a credit for everything because you messed up. You're 50% at fault or whatever it is. So that's what your percentage should be reduced by.
Gotcha.
And it's only the net amount. So it's not the gross amount of the settlement, meaning after attorney's fees and costs and things like that, it's whatever you receive that's subject to a credit.
Interesting. Good to know. So we have Jorge Garcia, who also left us a comment on one of our videos with the workers' comp settlements in California. He says, does your attorney collect any fees on future medical care after your case has been settled? That's a great question.
So if you settle your case with an open medical award, meaning that the insurance carrier is still on the hook for providing you care, and let's say later down the road, the insurance carrier comes back and says, hey, you know what? We want to offer your client a settlement to buy out your medical care. Or maybe the client comes to us and says, look, I'm not really using the medical care anymore, or I want to do this on my own. I don't want this open medical. We can sometimes go back to the carrier and try and settle out the value of their future medical care. In which case, if we do that, yeah, we take a percentage of whatever that number is. If we settle out your case lump sum where they buy out your medical care just in one go, rather than later, then yeah, our attorney fee is based on the total settlement amount, which is typically 15%. So yes, if you decided you wanted to settle out your medical later and we helped you do that, we would ask for a fee.
Interesting. Very, very informative. All these questions are coming in once again through our YouTube page, and we also go into the TikTok page as well, and we try to like engage and answer as much as we can, or at least provide some feedback. And we have so this was a little bit difficult to kind of understand.
Hit me with it.
All right, so it's a pretty long one. So
give me the Cliff Notes version.
These are, again, real questions. We don't make these up. So, can I ask, once the doc tells you that you are MMI, does the info get transferred over to the insurance company? And does the insurance company automatically contact you to discuss settlement or anything at all once the doctor tells you something? I've been MMI'd by my doctor and I haven't gotten contacted. What's up?
So a couple of things happen. Your doctor should write an MMI report outlining what your disability is, if any, as well as what your future medical needs are, as well as your permanent work restrictions. The permanent work restrictions should go to your employer so that they can engage in the good faith reasonable accommodation process to determine if they can offer you permanent modified work within your restrictions. But yes, the report should be sent to the insurance adjuster. And the insurance adjuster has an obligation to review the report. And if you are permanent stationary or MMI and you have permanent disability and you aren't working, then they should start advancing you permanent disability benefits.
Okay.
And so that's something that should happen automatically within 14 days of the last payment of temporary disability if you're receiving temporary disability, or if not, just within 14 days of receiving the report.
So there is a timeline from the moment that you get MMI to the moment that they offer you a settlement? You don't have to wait months?
Sometimes. It depends on what's going on internally for them. They may get it and be like, oh man, this report sucks for us. How do we fight this thing? You know,
Right.
like what do we do to challenge this? Or they may say, you know, hey, this report's great. We're fine with it. Whatever, you know, we'll settle on this. If they want to settle on it, usually they'll reach out to you pretty quick. Sometimes it depends. Yeah, sometimes it depends though. Their adjusters maybe not doing a great job, and they're just hoping the case kind of like goes away and you won't follow up on it, and that you won't pursue the permanent disability component. It may happen. You know, I've seen that happen for sure. They don't send out notices. They just kind of hope you disappear, you know?
Like, oh yeah, just go away, forget about it, don't even come back.
Especially if you've gone back to work and maybe you're not thinking much of it.
Right.
Maybe in your mind you're like, hey, so I got some temporary disability, or I didn't. I've just been getting medical care. I've been working the whole time. I went to this doctor. The doctor said I'm good now, and that's my case. I don't know any better, even though in the report the doctor says you have like 30% permanent disability or something, which is worth a lot of money.
Yeah.
But yeah, I'd say in most cases where the insurance adjuster is satisfied with the report, they'll reach out to you. They'll explain. They'll start advancing permanent disability and stuff. But,
Nice.
Yeah.
Should run smoothly.
Should, but doesn't, like 90% of the time.
All right, cool. So we have Bethy, who also sent us a comment on our Pacific Workers YouTube page. And this was in regards to another workers' comp settlement video that we did. The insurance will pay for surgery. Will the insurance pay for surgery after the 5 years and after a stipulated award if I need to reopen my case?
Yeah, so as long as you have a need for future medical care and as long as that care is associated with your date of injury, you have an ongoing lifetime, I guess, right to medical care. The issue with 5 years from your date of injury passing is that if your condition has become worse, you can't recoup that extra permanent disability. So if, let's say you injured your back, and 6 years later you need a spinal fusion, and the spinal fusion doesn't go right, and now you're crippled. Let's say you're 100% disabled, like you're just constant pain, can't walk, can't do anything. It's too bad, so sad. More than 5 years from your date of injury has passed. That's why, at least for my cases, I always encourage my clients to aggressively pursue treatment, provided that the doctor's confident it'll fix them or make them better, because there's always risk. And if your condition does deteriorate and it's past 5 years, you can't reopen it.
Yeah.
So, we do have cases, unfortunately, where people have treatment down the line and there's complications. In those instances, though, usually I'll try and meet with the client and I'll say, well, hey, it's been more than 5 years. What were you doing during that time?
Right.
And sometimes they've gone back to work. And sometimes we can say, hey, you know what? Maybe that new job made your condition just bad enough where now you needed the surgery.
Right.
And so we can file a new case against that current employer to try and allege the permanent disability associated with that. So we try to find ways to wiggle around that.
Right.
But there are some cases where people just naturally get worse. There's no new injury. They haven't been back to work.
Right.
And that's just the way the law is, unfortunately.
So it's really important to pay attention to what the doctor tells you right before you, or at least when you're getting dismissed, in the sense of, okay, I'm going to, settle with the steps. Like, is the doctor's giving me an option to say there might be a surgery down the line that's going to be successful, then you're good.
Yeah, and we always, when we settle out a case, if it's a compromise and release where they're buying out the entirety of the case, which means you can't reopen, we'll usually try and allocate some value to that, depending on the case. Because the client's giving up their right to reopen the case, which could be huge or small depending on what their medical needs are and what the natural progression of their injury would be otherwise. So we take that into account, but it is always a risk with STIPs, and we always tell people, look, pay attention to that 5-year mark. If you think you're getting worse, call us long before then.
Yeah.
Because we want to be able to file that. And we only have to file within 5 years. Once we actually file to reopen your case, you're good. It's just a matter of getting there first.
Right. No, that's a great tip. It's a timeline that people can say, hey, I have up to 5 years. I really need to reevaluate, maybe right before that mark, to figure out what my next move is. Otherwise, your options are very limited after that.
Yeah, and it's not just with the treatment. Well, it's not just with the permanent disability either. We see that come up a lot with body parts, where you can't reopen your case to allege that there's new disability to another body part after 5 years either. So, maybe you start developing a situation where you need treatment on a body part that wasn't initially part of your settlement. And that's subject to 5 years as well of reopening. So you have to be very careful about what your treatment needs are, what you think your permanent disability is going to be, whether your condition's getting worse or static, and things like that.
Awesome. Well, I think we can squeeze one more. And this is a fairly question that comes in all the time. And I think we've talked about it in some of our videos as well. And that is, can I get fired while I'm on workers' comp?
Yeah, you can, unfortunately. So California is an at-will state, which means employment's at will, and you can be terminated at any time for any lawful reason, provided you don't have a contract. And to the extent you're terminated, as long as the reason for termination is lawful, they can let you go. Of course, there's the potential, presumption for that employer of, why did they terminate you while you were on workers' comp? Why you? And I think a lot of employers don't terminate people because they're on workers' comp because of the potential blowback, because they have to justify a legitimate business reason for your termination. If you go out on workers' comp and then 3 weeks later they say, oh, you're fired, and they can't articulate a reason for it, they're maybe in some trouble for disability discrimination or retaliation. So it does happen. Usually when we see terminations, it's for cause. Meaning the employee got hurt, they went back to work, they were caught stealing or something like that. But a common one you see a lot, especially with migrant workers and people that aren't necessarily authorized to work in the U.S., is all of a sudden after their injury, the employer will be like, oh, you're using a fake social security number, you're fired. It's like, well, you employed that person for 6 years, and now all of a sudden, just after they got hurt, you found out their social security number is fake. Like, that's BS. That's discrimination, retaliation.
Right.
You guys knew exactly what you're doing hiring this person. You didn't verify their employment, all that stuff. So it's a common tactic we see to can people.
That sucks.
Yeah. And another example, I guess, would be of lawful termination would be if the company has a policy. So if the company says, doesn't matter who you are, our policy is that we will keep you on for 24 months following a work injury, and at that 24-month mark, if you cannot come back to work, we let you go. And if that is a business policy and it's administered for everyone, not just
Equally,
you
yeah.
equally, then that's probably okay. Because maybe they have a legitimate business necessity in replacing positions and
Right. They
doing
can't
things.
afford not having that one employee. Yeah.
Exactly. But again, they can't administer it differently depending on who you are, right? It has to be equally administrated across everyone.
Great. Awesome. Well, I think we have everything we can, squeeze in with the time that we have allocated for our podcast. But we do have some great news. We do have a live webinar where we are going to be sharing a lot of information regarding the California Workers Comp system. That's going to be virtual. We're going to be pushing it out on our social media accounts. So keep an eye out for that. Maybe you can join us, and there is going to be a live Q&A session at the end of the seminar. So it gives you this connection to make those questions in person as well. So that is going to be coming to you guys via social media.
If you're not tired of hearing my voice, I'm going to be explaining work comp start to finish as best I can, and doing my best to answer questions and stuff that comes up throughout the webinar. So
yeah, and it's not that long. It takes up to like 45 minutes to an hour. There's a lot of information that is being shared throughout this webinar. So we highly encourage you, if you know someone who's been injured and who's clueless onto how the workers' comp system works, or even if you're not injured, but you want to get a scope and an idea of how it works so that if and whenever you are injured, we highly encourage you to RSVP to this event. It's free. It's free of charge. We're not charging anybody anything. You can do it from the comfort of your home, and it's going to be a very detailed webinar for sure. So we'll be sending those details as well, or we'll drop them on the link on this YouTube video as well. But for the most part, thank you for answering those questions.
of course,
Thank you to everyone for asking the questions.
Keep 'em coming.
We'll catch you guys on the next episode of Work Comp Talk.